Is there anything you can do to avoid being liable for these two things? Yes, don't serve to anyone who appears intoxicated, and always check identifications. Who can sue me? The person injured can sue you. This includes someone who chose to get in the car with the person you overserved. This also includes innocent bystanders who were harmed. The family of the person injured can sue you. The person's parents, children, stepchildren, and/or spouse can all sue you. Each can claim his or her own damages. If there's a death, then the group of people who can sue you gets even bigger, expanding to brothers and sisters. Sometimes the person you overserved can sue you, particularly if that person was a minor, or if that person dies, his or her family members may still be able to sue you. What types of damages will I have to pay? Well, you'd have to pay for the injured person's pain and suffering, both the suffering already experienced and to be experienced in the future. The injured person's lost earnings. If the person died, that would be that person's projected lost earnings over his or her lifetime. You might have to pay for the injured person's medical and hospital expenses, even if that person had insurance. You could be sued for the loss of certain relationships. If a parent died, the child can sue you for losing out on having a mom or a dad. If a child died, the parent can sue you for losing out on having a child. If a spouse died, the spouse can sue you for losing out on having a spouse. How much money are we talking? As noted above, Utah limits the recovery to $1 million per person and a total of $2 million aggregate. Now let's talk about the criminal liability. Knowingly serving a minor is a Class A misdemeanor punishable up to 1 year in jail. Negligently, unknowingly, serving a minor is a Class B misdemeanor punishable up to 6 months in jail. Knowingly serving to someone who is apparently intoxicated is a Class A misdemeanor punishable up to 1 year. Negligently, unknowingly, serving an intoxicated person is a Class B misdemeanor punishable up to 6 months in jail. In bad enough circumstances, you can be charged and convicted of criminal manslaughter. What is manslaughter? Manslaughter is defined as recklessly causing the death of another or committing a homicide that would be murder, but the offense is reduced because the defendant caused or attempted to cause the death of another under reasonable belief that the act was legally justified or excused under the circumstances. A murder charge may also be reduced to manslaughter if certain mitigating factors exist, such as mental illness or extreme emotional distress. This actually happened in Kansas in the year 2007 when a man was charged and convicted by a jury for manslaughter of overserving an obviously intoxicated patron who eventually died of alcohol poisoning. The man was sentenced to 4 years in prison. In Utah, the punishment for manslaughter is up to 15 years in prison and a $10,000 fine.